73 will be subject to 4 restrictions, limitations. The law has to be limited to practice and procedure. Secondly, the law cannot colonize or abrogate the primary role of the Supreme Court to frame rules. So if your lordships come to the conclusion, I don't support the view that Parliament can simply abolish the Supreme Court rules. That will destroy the complete autonomy of the Supreme Court. But if you
can there be an implied repeal? Mr. Salahuddin took the position that it can be expressly repealed. Can there be an implied repeal?
There can be implied repeal, but does that amount to destroying the power of the Supreme Court framing rules? That has to be seen provision by provision.
There can be implied repeal. Why can't there be express repeal?
No, there can be express repeal in relation to specific provisions. The third.
So what you're saying is that if there is a rule is made and consequently Parliament can undo that rule by making a law, so then the law will prevail.
Not in every circumstance. I'll explain.
How does one understand this second point of yours?
By the third point.
It does not abrogate the role of the Supreme Court.
By the third point.
Which we are awaiting to hear.
Thirdly, no provision of such law can violate the constitutional of the judiciary. So your has to look at every provision and see whether the repeal which has taken place of a particular provision impacts the independence of the judiciary or not. That is the method, and that is the thing which has been laid down in a Supreme Court judgment, will I judge side. The fourthly, no law can restrict jurisdiction or powers of the court on a harmonious reading of entries 55 and 58. So there is, these are the limitations on Parliament.
What about separation of powers? What about the constitutional principle of separation of powers? I find that missing over here. Why should that not be also a limitation?
My lord, I take that within the notion of the independence of the judiciary at the heart.
That's a separate thing.
Counsel,
they are two separate things.
Separation of powers is not restricted to the judiciary.
Yes.
What if the judiciary starts encroaching upon the powers of the legislature and executive? And that is how...
पांचवा डाल दें, क्या फर्क पड़ता है? कोई फर्क पड़ता है?
So can I mean there's a system of checks and balances as well.
Yes.
So the Parliament is empowered to legislate, and all that they have legislated is something which ensures to justice.
That is what I will show when I come to provision by provision, that none of these provisions.
Can you elaborate a bit more on your second one? The court cannot colonize or abrogate the primary role of the Supreme Court to frame such. Kindly elaborate a bit more.
Example of that is the Bas Kakar case. It's a classical example as to why the Supreme Court struck down that law. What in the Bas Kakar case, the Contempt of Court Act 2012 did, is that in terms of actual cases pending before a particular judge, in which that judge had taken cognizance of, for example, a contempt on the face. In that, legislature interfered and that said that that case will go before another judge.
That's not practice and procedure. That's not practice.
No, but I'm saying that is that.
No, but Bas Kakar was decided in the context of Article 205.
No, I'm giving you an example.
But that was a different context. Give me an example of 191 when you say.
I'll give you an example.
Colonize or abrogate.
I'll give you an example. Let's take section 2. If there was any rule.
आप जरा example नहीं, मुझे जरा पहले इस principle को जरा समझाइए.
वही मैं principle.
आपकी limitation क्या है?
Example से principle को. Let's say that section 2 envisaged some kind of role of the executive in the constitution of the bench. That I
section 3 actually.
Section 2 sir committee जो बनती है, एक committee member chief
3 में है ना
जी
3 में
2 में है ना 3 में तो वो है ना सर मेंटेनेबिलिटी वाला सर.
Sorry 2 में है I would regard that as colonizing the.
I know your lordship comment about
you've used very interesting words.
Colonization.
Colonize, तो colonize.
बस ये literature पढ़ के थोड़ी सी गलत
हो गया ना इसके अंदर. इसलिए मैं आपसे ये you're making an interesting point, but I want you on the plane of principle kindly to explain this point further.
Sir, this cannot be preemptively elaborated. This can only be understood through example, because one doesn't know. Your lordship has to examine this provision by provision. That is why what I would be suggesting, that there is a debate between that we should open the door and not be afraid of it, and there is a suggestion about closing the door. I would say keep the door open, but there should be certain padlocks on it.
नहीं उसके अंदर
The other way is that you keep the door open, but the watchdog is sitting.
Yes.
And watchdog ensures that nothing, fundamental rights are not violated. So all your 5 points could be summed up by saying that as long as that law doesn't violate the fundamental rights, which includes access to justice, independence of judiciary.
Siddiqui साहब,
ये जो आपने बात की है second, ये आपको जो
Siddiqui
second है,
साहब,
how does that square with the implied repeal?
जी.
आपका ये जो second point है ना,
जी.
secondly the court cannot colonize or abrogate. आपने अभी कहा कि implied repeal is possible.
Yes.
Kindly explain to me
Sir,
how.
जी.
As a principle,
sorry.
principle की बात करें. I mean, don't go into the nitty-gritty right now. वो तो आप आगे जाके करेंगे. मैं आपका principle समझ रहा हूँ. How does this square with the? You say there can't be express repeal, but how does this square with implied repeal?
No, sir, there can be express and implied. What Mr. Salahuddin argued, that the parliament can get rid of the entire Supreme Court rules. I am not advocating that on a particular rule.
How do we identify the core that cannot be repealed?
Yes.
Mr. Faisal, the core would be that in case, Mr. Salahuddin might be correct, you see, they can strike down the entire set of rules provided they don't violate the independence of judiciary. Your argument is the same.
No.
I stand on any provision. Suppose theoretically speaking, if you bring out a law which takes away all the rules that are there, but it doesn't affect the independence of judiciary, maybe enhances the independence of judiciary, what's wrong?
My lord, I think what is underlining 191, and this is something which should be safeguarded at all circumstances, is at the heart of 191 is not the law made by parliament, but the internal autonomy of the Supreme Court.
There has to be some
Siddiqui
principle.
साहब, my question please.
जी, जी, जी.
ये आर्टिकल 191 की जो लैंग्वेज है that starts with subject to the law and the constitution. There are very few articles of the constitution which starts with the word.
There are only 3.
Only 3. Yes. So does it means that because the constitution was framed in 1973 and the rules were framed in 1980, do you think that there is still a room is left for the improvement in the procedure with the passage of time? Like 184(3), whenever it has been used, ये पूरे मुल्क की बुनियादें हिला दी इसमें जब भी इस्तेमाल हुए. तो do you think there is a room left for improvement in Article 184(3) or the procedure of the Supreme Court?
My lord, I think
Intentionally that has been done.
whatever amendments, and I'll take your ladyship through each of the amendments, whatever amendments have been done, I think that shows that reform is required under Article 184(3).
So can I just understand? आप ये कह रहे हैं कि 191 enables Parliament to make law.
Yes.
The principle to apply will be the independence of the judiciary. So the independence of the judiciary and the ability to make rules should be protected and preserved. But Parliament can make law with reference to practice and procedure.
Yes.
If they do make that law with reference to practice and procedure, so that's not undermining that principle of independence of the judiciary, but then we go into the provisions that
Yes.
they'll start making of practice and procedure, and so then see whether that meets. So then my question is that isn't the constitutional mandate the opposite? Isn't the constitutional mandate saying that the Supreme Court, to the extent of how it regulates practice and procedure, will do it itself, because that is in its own internal matter, and the only thing that's stopping the rule-making ability is anything expressly provided in the Constitution or by law. Like I said yesterday, limitation है, court fee है, इस तरह की चीजें हैं, which are procedure related, which you can't override through your rules. So एक system बना हुआ है, उसके अंदर they govern themselves internally. And it's interesting that in these 3 days of hearings, nobody has actually said to the Supreme Court that this is your rule-making power. What is stopping you today from making these rules? And why don't you exercise this power and call a full court meeting and actually exercise this power and bring whatever change you think today is acceptable? We are ready to argue this point and go into the delicacies of subject 2 and whether this is an expansion of jurisdiction or not. और आपके मुताबिक तो Supreme Court appeal की right भी दे सकता है. So problem किधर है?
If appeal is read into as procedure.
The point is कि अगर हमने independence of the judiciary को guard करना है तो where is the limit? कहाँ guard करें? Guard करें.
Your ladyship is.
What principle should I follow?
Your ladyship is absolutely right. There is nothing stopping the Supreme Court from reforming itself, but a much more fundamental principle is involved.
Tehsil, इस पे एक example, just to quote an example, in Germany and in South Africa, they have adopted the concept of the lawful judge, and I'm sure you must be aware of that. और उसके लिए उन्होंने 11 criteria laid down किए हैं कि how the cases are fixed and before which judges they will be fixed. So there's no intervention by any master of the roster. It's all through, if the parliament tomorrow, in the interest of the litigants, legislates and on these lines, would they be to do that, and would that in any way which protects the interest of the litigants affect adversely the independence of judiciary?
Look, that is my precise point, that the issue is that does 191 create this delicate balance between preserving the internal autonomy of the court but at the same time give a check and balance to the legislature. That's the central point. That is why, regardless of whether there are internal reforms or not, the parliamentary role cannot be eliminated. But the parliamentary role, of course, has to come within the ambit of 191.
What would be the status of the Supreme Court in making rules in presence of this Act? Whether the Supreme Court can enhance power in making committee from 3 to 5?
My Lord, the first thing is, and this goes back, connecting both your questions, goes back that in terms of these rules, of course, there are certain rules of the Supreme Court right now which are in conflict with these rules. Like Section 2 of this Act is in conflict with Order 11. The review, the right to counsel, new counsel, is also in conflict with that. The Order, I think, 27 or 37.
Take a stand, Mr. Siddiqui.
Yes.
Take a stand. Don't beat about the bush.
Yes.
Direct question has been asked to you.
Yes.
If tomorrow the full court says that this committee consists of 5 members, can they do it? Or will the law, this act be the, Section 2 be the constraining, limiting power?
Or is there any restriction in the Act?
Give a straight answer.
Sir, after this Act, I don't think there will be enhancement in terms of Section 2.
So that means the Act trumps the Supreme Court.
That's why, because it doesn't, unless and until your lordships can, someone can challenge Section 2 on the ground that having a 3-member committee violates fundamental rights or the independence of the judiciary. If you can't challenge that, then enhancement.
Are the rules binding on a bench? Whoever makes the rules of the Supreme Court, are they binding on a bench of the Supreme Court?
Yes, I think that's the law. The rules would be binding.
On the bench itself?
Yes. Unless that particular rule is suspended through a judicial order.
No, on a bench. The rule made through administrative power, is it binding on the Supreme Court exercising judicial power?
Delegated legislation which is made under Article 191, I think. So I think the rule would be binding, and there are numerous judgments.
We are talking about now constitutional matters here. Let me finish my chain of thought. there is a rule, whatever the rule says, a 3-member bench says that the rule, in our opinion, contravenes some fundamental right.
Yes.
Therefore, we will not strictly follow it. So surely it's not binding, or you're saying that the bench cannot pass such an order?
No. I'm saying unless, if your lordship declared the rules as ultra vires or a particular rules, of course they are not binding, but unless that
Okay,
is...
now we take the discussion a bit forward. If a bench of this court states that the rules under 184(3) have not been formulated in the Supreme Court Rules 1980, and therefore matters, till such rules are made, such matters should not be fixed for hearing, excluding habeas corpus matters. Can such a bench pass such an order?
If there is a constitutional basis for it,
I'm just asking you a thing, yes.
My lord,
184th at existing,
My lord.
I'm not talking of hypotheticals, I'm talking about the rules 1980 as they are. A bench of this court says since 184(3) petitions have been filed and the mode and manner of how they should be heard has not been determined in the rules, can a bench pass such an order?
Yes, a bench can pass such an order if the bench can show...
And can the bench then say, let the full court make such rules?
On the first part of the question, the bench can pass such an order if such a restriction can be inferred or is present in Article 184(3), that 184(3) powers cannot be exercised until rules are made. If the bench holds that rules, unless rules are made...
I'm saying if, no, I'm saying it has done it. Now, you say it's not permissible or it's permissible.
If a constitutional basis can be shown for
Yes.
that, I think, of course.
Okay.
I mean, if the rules are violative of the
When
Constitution...
there has been a case where a bench,
Yes, I know,
very
I'm aware
bench of this court said that the rule should be enacted by the full court.
Yes.
Now, if even exercising judicial power can be thwarted by saying no, then how do you get the rules made? It all depends now on the person of the Chief Justice. So please explain that to me. I mean, why are we just skirting the issue, hypotheticals? Why are we not coming to actual practical things which are happening in Pakistan where cases have been decided and sort of all over the place, just take the bull by the horns and ask.
Sir, I'll come to that. I'll just cite two judgments.
I mean, I just want to know the clarity on this issue.
मैं वो खत्म कर दूं, 1 मिनट दीजिएगा मुझे, सिर्फ 1 मिनट. There are two judgments, if your lordship, and I will not read them because I've already...
You can just add to that. Parliament can't make it. The judicial order cannot ask for these being made. So at the end of the day, it is all power vests in one individual called the Chief Justice of Pakistan, and that is
That is exactly my next point, but I'll just, because I just want to hurry. There are three judgments which your lordship may look at. At page 5, the first judgment, 92 SCMR 1208. This is where I draw this principle, where Justice Ajmal Mia,
12?
Sir, Afzalullah, sorry.
No, 120?
1202, where they say that we will not follow such statute provisions and it will not override the rules which violate the independence of the judiciary. So this is where I draw that principle. There are two judgments.
But this judgment says that the rules will prevail
If
over the statute.
Yes, if the statute violates the independence of the judiciary, that's the criteria. But as a general principle, there are two judgments. One is from India, AIR 1964, Supreme Court 855. It's all written there, in which this conflict came before the Indian Supreme Court.
Where is it written? In your booklet?
page 5, top of
Sir, ये page 5 पे first 2 पैराग्राफ देखिएगा, और अगर ऊपर ही देखिएगा तो मैंने एक जजमेंट दी है AIR 1964 Supreme Court 855, in which a conflict between a rule of the Indian Supreme Court as well as an act came, and they said the act.
I still don't know, you again around. Simple proposition is, no, sorry, you have to answer these questions. So all power vests in the Chief Justice, not in the full court, because full court is then dependent on whether the Chief Justice wants to call a full court meeting or not. The last full court meeting before the one that was called on 18th of December was about 4 years before. Prior to that, a lot of issues had accumulated which have still not been addressed through the full court meeting. So why are you hesitant in calling a spade a spade?
Sir, I'll answer that question now. My lord, the proposition which has been put forward, and this is one of my objections on the Ghulam Muhyiddin case.
फिर आप इस पे चले गए।
जी सर,
आप जवाब तो दे
मैं दे रहा हूँ
तभी आप इधर चले जाते हैं।
That is the first
नहीं
case.
नहीं
मैं जवाब दे रहा हूँ।
आपको मैंने एग्जांपल दे दी है।
जवाब दे रहा हूँ, मैं जवाब दे रहा हूँ प्रिंसिपल स्टेट।
अरे चले मैं आपको बता देता हूँ, अब चलें हम इस कानून को उड़ा देते हैं, ठीक है? इस कानून को हमने उड़ा दिया, ऐसी मफरूजा दे रहा हूँ, ये कानून उड़ गया, ठीक है? अभी कोई रूल बनाना मैं नहीं फुल कोर्ट मीटिंग करता हूँ, आप करेंगे क्या मुझे जरा बता दीजिए। नहीं ये देखिए फैसल साहब, you are a highly acclaimed constitutional lawyer, so praising me or anyone else should not be a substitute for responding to a query. A constitutional query I'm asking you.
अभी यही क्वेरी आपका।
फिर आप इस केस में ले जाएंगे गुलाम मुहय्यिद्दीन में।
अब मैं कोई केस साइट नहीं करूंगा, आपके सवाल का जवाब दे। सर, the independence of the judiciary is not linked or is not threatened if the role of the Chief Justice is reduced. Now, that is not the principle. That I think
it took you a long time to say that.
Yes. No, I've written that here, sir.
You haven't said it.
Here. So this whole debate that the master of the roster must be the Chief Justice has been elevated to a constitutional principle. It is nowhere in any case law as a constitutional principle. As Mr. Salahuddin rightly pointed out, its whole basis is in terms of judicial history and in terms of statutory law. Ghulam Muhyiddin case is the first case which lays down that the Chief Justice, being the master of the roster, is linked with the independence of the judiciary. Your Lordship will find no case which makes this link. The link has always been with the independence of the judiciary linked with the Supreme Court itself, not with the particular...
As far as the interpretation of judgments, whatever has been decided, you can give a lecture in a law school. Here the full court of Pakistan is sitting. We don't want to be given a lecture on precedents. We want to be enlightened by the understanding of the Constitution, which we keep saying is an organic thing, pulsating, evolving, catering to all sorts of situations. I mean, if you're just going to be stuck with the case law, then we should just take a lecture in some law school.
My answer is...
There is no constitutional input then coming.
My answer is that there is nothing in the Constitution...
The context of that, what you're citing from that judgment is legislative intervention. The problem is not whether the Chief Justice is the master of the roster. That is not the context of what we are considering now. The context is, and let me therefore ask you the question which I have asked Mr. Salahuddin and Mr. Zaid Ibrahim.
I thought if we talk about which question comes first, now another question has been put on another question. Can you answer mine and we get on with it, and another question can be asked. So please don't mix up my question with other questions. You respond to my question. Let another question be asked after you've given an answer, or you can keep your answers safe till you finish your submissions.
Well, Lord,
I don't want my question to be added on to when I have a clear-cut question. Hopefully you've understood it. If
yes,
you haven't, I will explain it further.
Yes.
Thank you.
If I may answer that question. Sir,
I thought you'd finished with your answer.
No, sir. Thank you. Sir, my answer is that reduce...
Never take my permission.
सर
डबल स्टैंडर्ड
नहीं सर आप मुझसे
मेरी कोई बात नहीं लाइन टू नोट आगे बढ़े
बड़े सवाल कम पूछे इसलिए मैं रिलैक्स्ड हूं
Are you taking the permission from
चलिए आइए आगे बढ़िए
सर जी sir there is nothing in the Constitution which equates the Chief Justice with the Supreme Court. And what has this law done?
Why don't you say so? End of story. What's more to be said
Sir,
then?
what is this law? सबने
Mr. Siddiqui,
एक
आपका आंसर हो गया?
sorry.
Is this your answer?
नहीं आंसर हुआ है, बात तो कर लीजिए, बात कर लीजिए फैसल सिद्दीकी साहब। मैं सबसे आज मैंने सबसे कम सवाल पूछे।
सेक्शन 2 पे तो फिर आपका ले लूं।
सिद्दीकी साहब, मैंने आज सबसे कम सवाल पूछे, कम से कम यही राइट मास्टर ऑफ द रोस्टर को दे दीजिए।
इसका जो कॉन्टेक्स्ट है ना, वो बात का वो ये है, जो मैंने सवाल उनसे किया था अपना सलाउद्दीन साहब से, जाहिद इब्राहिम साहब से, दिस लॉ, आप तो इसको बहुत रिस्ट्रिक्टेड कर रहे हैं ना, बट व्हाट दिस लॉ डज इज it makes Parliament the master of the roster for the Supreme Court of Pakistan.
Nothing in this law will do.
इसको ये असर, इस सवाल का आप जवाब दीजिए।
My lord, there is nothing in
जवाब
this.
दीजिए पहले साहब के
There
सवाल।
is nothing in this law which makes Parliament the master. I mean, what has happened to the Chief Justice under Section 2? Has his role been eliminated? He is one of the members of the
No, you're
committee.
missing the point. You were present.
आप अपना जवाब तो सुन लेना आपका पहले, आप जवाब दीजिए प्लीज।
Sir, in terms, because there is no constitutional provision which gives this elated position to the Chief Justice, and the Chief Justice is equivalent to the Supreme Court. For example, giving the power of the constitution of benches to three senior most judges, how does that violate the independence of the judge?
I'll tell you.
आप बात तो कंप्लीट करिए प्लीज।
Because it is, that committee is the creation not of the full court, but
मैंने आपसे दो तीन बातें और भी पूछी थी। अगर चीफ जस्टिस फुल कोर्ट ना कॉल करे, अगर चीफ जस्टिस कुछ ना करे, तो फिर पार्लियामेंट ने किया एक काम, ठीक है, मुझे करना चाहिए था, नहीं किया मैंने, तो किसी दूसरे ने कर दिया, तो अब वो कॉम्पिटेंस है, तो अगर मेरे ही में कॉम्पिटेंस है, चलिए वो बात भी मान लेते हैं, नहीं है तो फिर इसका मतलब एक लॉक जैम हो गया, क्योंकि चीफ जस्टिस ने कहा मैंने तो करना नहीं है किसी सूरत में, और मैं किसी और को भी नहीं करने दूंगा। तो बुनियादी बात तो यहीं आके ठहरती है ना। अब सादी बातों को सादे अल्फाज में बयान कर देना, इतने जजमेंट जी पहले इशू आया नहीं था सुप्रीम कोर्ट के पास, तो नया इशू है, तो आप ज्यादा आइन को मद्देनजर रखते हुए उसकी तशरीह कीजिए ना। अगर हम आइन की तशरीह सिर्फ जजमेंट से करने बैठे तो फिर हम एक टेक्स्ट बुक उठा लेंगे, पढ़ लेंगे, उसमें वकीलों की जरूरत नहीं है, उसके कॉन्स्टिट्यूशनल लॉयर्स की भी जरूरत नहीं होगी। आप कहिएगा फला आप पढ़ लीजिए बुक ऑन कॉन्स्टिट्यूशनल लॉ, आपको सारे जवाब मिल जाएंगे, नहीं, वहां जवाब नहीं मिलेंगे, क्योंकि अब जो चीजें हम अब देख रहे हैं वो पहले नहीं देखी गई थी, और हो सकता है पहले गलत देखी गई हो, ये भी मुमकिन है। तो अपना विजन खुला रखना चाहिए, बेशक वो मेरे खिलाफ बात हो या मेरे फेवर में हो। इधर तो मैं अपने फायदे की बात नहीं कर रहा हूं, जो आपको इसमें कोई रुकावट होना चाहिए कि आप चीफ जस्टिस के सामने खड़े हों और चीफ जस्टिस कह रहे हैं कि आप मेरे इख्तियारात में कमी ला रहे हो, तो आप हिचकिचाहट क्यों, आपकी तरफ से क्यों ये हिचकिचाहट है?
मैंने तो क्लियरली स्टेट, एंड सर वी शुड आल्सो नॉट फॉरगेट, Lordship has mentioned again and again that here the legislature is being given the power to tell us how roster will be set. Who will constitute? Sir, the Supreme Court is the creation of the legislature.
No, we are the creation.
It is the creation of Parliament.
Of the
That should also not be forgotten.
We are the creation of the Constitution. Constitution says now we the people of
but
Pakistan.
the people through their representatives.
The people of Pakistan.
So my lord, this is also legislation by the people.
The problem with the committee is not that there is a committee. If the full court had made the committee, that would be a different thing. The committee is the creature and creation of Parliament. It is the Parliament's will that is prevailing, and therefore at the plane of principle, for which you don't need any textbook.
मेरी इब्तिदाई बात ये थी
is that Parliament becomes the master of the roster. This is my question.
मेरी इब्तिदाई
मेरी
जो इब्तिदाई बात थी वो ये थी कि अगर चीफ जस्टिस फुल कोर्ट मीटिंग कॉल ना करे, इब्तिदाई बात थी, इब्तिदाई, तो पार्लियामेंट की बात और फुल कोर्ट की बात तो रहती नहीं रहे ना। इब्तिदाई बात का आपने उसको भी आपने नजरअंदाज कर दिया। आप कोई पोजीशन ले लीजिए कोई,
Sir,
आप हमारे इंटरेस्ट के खिलाफ भी ले लेंगे पोजीशन, हम आपसे नाराज होंगे।
the point is issuing writs against a writ petition being issued, I mean a constitutional writ being issued against the Supreme Court itself. I think that requires will you some thought process. I mean, I can't answer that.
Will your
question
only
offhand.
remedy then be to file a writ petition against the Chief Justice to convene a meeting of the full court?
My Lord, I think...
Or there is no remedy?
No. I think it's a question which requires serious consideration. I can't answer that question without seriously thinking about it. But because the Supreme Court did not do anything about these issues, that is why Parliament intervened.
Don't use the word Supreme Court. Use a please. You don't condemn all of us or any of us. The Chief Justice. If it is to be condemned, then point me to the Chief Justice. Don't say the Supreme Court. Sometimes they use being interchangeably. I think they're very different. The Chief Justice, all 14 of my colleagues want to full court meeting. I don't want to call it. End of story. So are they all to be condemned equally with me?
Sir, we all have our sins, we all have our weaknesses.
देखिए ये बातें देखिए अगर आपको ये हम फिर आईनी बातें नहीं कीजिए ना, फिर असूली बातें ना करें। फिर आप कहें कि जी हमें सबको खुश रखना है, एक गाड़ी चलाना है, हम सबको खुश रखते रखते बहुत सारे मसाइल खड़े हो जाते हैं। साफ-साफ बात करें, इसमें मुश्किल बात क्या है?
I have categorically stated the position.
इसमें एक बात ये बता दें कि क्या चीफ जस्टिस पाबंद है रूल के? क्या चीफ जस्टिस ने रूल के ताबे हल्फ उठाया या कॉन्स्टिट्यूशन और लॉ के ताबे हल्फ उठाया?
सर,
तो चीफ जस्टिस की मर्जी हो, चूंकि हल्फ नहीं लिया रूल के, इसलिए कहते मैं जो करते हो कर लो।
I think the point is, your lordship knows the answer to that. I mean, there can't be a rule, there can't be a law which violates the
coming back to the question of interference in the independence of the judiciary, Section 2 and 3, they clearly vest the legislature with the power to constitute benches, to fix their number, and it makes it obligatory.
Let's take Section 2.
Obligatory to do so.
So let's say Section 2.
Fair enough.
Yes.
Now, if it makes obligatory to do so, it is actually dictating the committee how to act.
No,
is
sir.
that not interference?
Okay,
the committee says, okay, we don't follow.
There are 3 members, the Chief Justice, who used to do it on its own, now does it along with his 2 senior colleagues. How can that be a violation of the independence of the judiciary?
What is wrong is that an entity which has nothing to do with the internal working of the Supreme Court is interfering.
My Lord, if you eliminate...
When it is interfering, it is directly affecting the working of the court, and it's a handle on the Supreme Court to pick and choose in what way it wants the matters to be heard.
I think I will agree with Ijaz Sahab and I'll take it forward. And why don't you say, yes, it is interfering? Let's say, let's accept it for the sake of argument. Yes, it is interfering. Why don't you say, because the Chief Justice, you are not doing your job? Why can't you say that?
So the very
why? What's the hesitation in saying that?
No, there is no hesitation.
Because you are not fixing urgent cases. You are fixing cases at random, which may, I mean, I'm putting this allegation on myself. So let it not be understood that I'm putting it on somebody else. I'm fixing cases which I want to. I'll say Mr. Faisal Siddiqui's cases will not be fixed at all. Your practice goes for a 6. I'll say only cases of Mr. Abid Zubairi should be fixed, or whatever, whichever counsel should be fixed. Okay? You can't do anything, right? But so why don't you say, even if it is interference, it is good interference? Now the only question, back to question of my lord, जो जज साहब ने पूछा था पहले ही दिन से पूछ रहे हैं, और वही मेरे ख्याल में असल सवाल है, कॉम्पिटेंसी की वाली बात रह जाती है. अदरवाइज व्हाई यू हेसिटेटिंग? से आप लोग अपना काम सही करें तो यह ना लेजिस्लेशन की जरूरत बनती ना कुछ. अब जब लेजिस्लेशन बन गया, हम कहेंगे हम किसी से अकाउंटेबल नहीं है. हमारे पास जितने केसेस बढ़ते जाए हम फैसला करें, ना केस एक केस सुने दिन में 50 केस सुने, हमारी मर्जी है. ठीक है, नहीं सॉरी, इस तरीके से नई चीजें चल सकती हैं. हर अदारा को खुद एहतसाबी करना होगी सबसे पहले, इससे पहले कोई और उसकी एहतसाबी करे. तो पता नहीं, ये सीधी सीधी बात है. अब सीधी सादी बातें करें. केसेस में हमें उलझा करके घंटों चल रही है बहस. मतलब
frankly, when I look at Section 2, I see no violation of the independence of the judiciary. Yes, if that principle that under no circumstances Parliament can ever say anything about constitution or benches, then of course then section 2 goes. But I don't think if anyone point out any element which violates the independence of the judiciary in terms of the committee, and it is a misnomer that the Chief Justice is no longer a part of the constitution of the bench. He's one of the members. His role has not been eliminated. I move on to the second one, which is the most difficult one, which is, and Justice Shahid had asked a very important question about framing rules. Framing rules. And I've dealt with that in my note. Your Lordship may have a look at that. But I'll move on to the second. But that's a very important question. There is no provision which says that rules should be framed. It says determining procedure, and I've tried to answer that in my note. Thank you, sir. Sir, 3. Now, it's a very important, this is the only provision which I would ask your Lordships to read down. This is the only provision.
Which is
Section 3, sir.
3.
What Section 3 does is that it says that there is this committee will at an initial stage look at whether these petitions are maintainable, whether the two conditions in Article 184(3) are present or not. Does it satisfy it or not? Now, this is clearly, as His Lordship Justice Mansoor has held, this is clearly a judicial adjudication. And this committee is really acting on the administrative side. It's obvious from the language of this provision. Now, there is nothing unusual, of course, about this initial, examination of these. The US Supreme Court does this. There is no hearing, there is no at the leave granting stage. So the real problem is not that. The real problem is...
There is a problem here. With all due respect, your analogy is wrong. And I'll tell you why your analogy is wrong. The Supreme Court of the United States applies what is called the rule of 4.
Yes.
That out of the 9 judges,
yes,
at least 4 must agree to hear the case. That case goes to full hearing. But this scrutiny that you're talking about, that is not done by a committee of 3.
That is why I was going to add.
That is committee, because they all sit en banc.
No. So that is what I was saying. What is not unusual is no reasons and hearing is given.
No, that is not the problem with Section 3.
Sir, मैं वही तो बता रहा हूँ. Your Lordship is saying that when those 4 judges sit,
No, it's not the 4 judges. They have what are called conferences. I think every second Saturday they have a conference in which all 9 judges sit, and the cases are put up in conference. Any case that musters 4 votes out of the total 9.
Yes.
It's not a committee of 4 that sits. All 9 sit. The full court sits. What we would call the full court. That sits, and if 4 out of those...
and 5 when there is a grant of a stay order.
Sorry?
5 when there is a stay order. Yes.
आप तो सेक्शन 3 की बात कर रहे हैं ना?
जी.
तो अगर 4 जो हैं वो नहीं, 4 वोट उसको नहीं पढ़ते, what they call cert denied. ठीक है? So it's not that there is a separate committee. Whatever they do, because they have their own, because they always sit en banc. यहाँ पे मसला क्या आ रहा है कि 3 जो what my learned colleague Justice Mansoor Ali Shah has stated in a very clear statement of principle, that the power of adjudication cannot be in the hands of any administrative committee. The context in which my learned colleague gave judgment was registrar, but as a matter of principle, with all due respect, it doesn't matter whether it's a committee, no matter how eminent or senior those judges are, the problem remains the same. So the US example, I'm sorry, is not...
I was giving it for a different reason. If your Lordship...
आप ये बता दीजिए कि अगर हम देखें एक मुल्क से दूसरे मुल्क के एग्जाम्पल्स हम देते रहते हैं, हम ये भूल जाते हैं कि अमेरिकन सुप्रीम कोर्ट में 120 केस से सालाना फैसला होता है. अगर आप सुप्रीम कोर्ट, अगर आप इंग्लैंड की बात करें तो पहले नंबर्स हमें थे. हमारा सिस्टम बिल्कुल फर्क है. हमारे सिस्टम में हर कोई सुप्रीम कोर्ट जब तक नहीं आता खुश नहीं होता है, या CPLA में आएगा या CLA आएगा. वहाँ ये सिस्टम है ही नहीं, बहुत कम केसेस होते हैं. तो अगर आप हर केस पे बैठ करके फुल कोर्ट ये तयन कर सकता है कि वाले सुन लें ना सुन लें, तो आप ये सारी बातें फिर बताइए ना. अगर आपको एक एग्जाम्पल दूसरी जगह से लगाना है तो फिर अंग्रेजी में कहते हैं कंपेयर एप्पल्स विद एप्पल्स एंड पेयर्स विद पेयर्स। ये तो नहीं हो सकता कि आप एग्जाम्पल ले लें और उधर तो जी 120 केसेस हैं, अच्छा 120 केसेस में अगर पूरा अमेरिकन सुप्रीम कोर्ट बैठ के तयन भी कर ले तो कितना वक्त लगेगा? आप बैठ करके 56,000 केसेस को तयन कर लें, वो बात ही नहीं होगी, वो अलग बात है।
तो ज्यादा होते हैं जी।
Clarify.
आप बताइए।
Cases run in several thousands.
जी several thousand.
Out of those only
जी
100 or
हमें
odd
देखिए जो चीज हमारे पास है नहीं, मुझे नहीं पता, अगर आप कोई चीज फाइल करें हम पढ़ लेंगे
Sir,
उसको।
the only reason I cited that,
जी।
I agree with you.
Supreme Court की Wikipedia पे
I agree. I actually agree with you. What I'm citing is, the problem with the provision is not that reasons are not given or there is no hearing. The problem is this maintainability adjudication cannot take place on the administrative side by even a committee.
आप रिपीट कर रहे हैं बार बार।
लेकिन इसका हल क्या है? इसका हल क्या है?
रीड डाउन करें,
इसको रीड डाउन कर दें और रीड डाउन इस तरह करें कि द स्क्रूटनी में टेक प्लेस, बट व्हाटएवर द पिटिशंस आर विल शुड बी पुट अप विद द स्क्रूटनी टू अ जुडिशियल बेंच. दिस इज द वे टू से. ये सिर्फ ये आपको करना है और नॉट मेंटेनेबल.
वकील साहब, आपने सेक्शन 3 पढ़ा नहीं है
जी.
उसका आखिरी पार्ट पढ़ें.
जी.
आप जो रिपोर्ट की बात रीड डाउन करने की कर रहे हैं
जी,
इस सेक्शन का आखिरी पार्ट पढ़ें.
Sir, I'll read the whole. Any matter invoking exercise of original jurisdiction under clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under section 2 for examination, and if the committee is of the view that a question of public importance with reference to enforcement of any of the fundamental rights conferred by chapter 1 or part 2 of the Constitution involved, it shall constitute a bench comprising not less than 3 judges of the Supreme Court, which shall also include the members of the committee for adjudication of the matter.
आप जो बात कर रहे हैं ना, अगर committee हो तो ये आखिरी words जो हैं they would need to be eliminated.
No,
obviously
no.
Committee, so the three member committee वो इसको scrutinize करे.
Yes.
Say not maintainable, puts it up before a 5-member judge, of which
No, why 5-member bench? 3-member bench? अभी सिर्फ ये वो केसेस पुट अप करेंगे
से मेंटेनेबल फिर
नहीं. यस, ये तो हर सर चेंबर में अपील जाती है. इनिशियली एक डिसाइड होता है मेंटेनेबिलिटी का इशू. दैट डजंट बार द कोर्ट फ्रॉम डिसाइडिंग द मेंटेनेबिलिटी क्वेश्चन व्हेन इट इज पुट बिफोर अ जुडिशियल बेंच.
सवाल जो उन्होंने पूछा वो ये है कि अगर फर्ज करें ये कह दें कि नॉट मेंटेनेबल,
Yes.
देन व्हाट वुड बी द रेमेडी अवेलेबल टू द
No.
इंडियन पर्सन?
अगर वो कह देते हैं नॉट मेंटेनेबल, आई वुड से दिस इज व्हाट योर लॉर्डशिप हैज. इसमें सिर्फ ये कहा गया है कि जो मेंटेनेबल होगा वो बेंच के पास जाएगा.
नहीं, अगर फर्ज करें वो नेगेटिव में उसका वो
आप
कर
जो
दें,
read
तो
down-
फिर भी बेंच के ऊपर पास जाएगा सर.
सही जाएगा. कहाँ लिखा हुआ है?
सर यही तो रीड इन करना है. यही रीड इन करना
बात सुने, उसमें ये भी लिखा
यही
हुआ है
read in करना है. That is-
which may include members of the committee.
Yes.
So notionally, it can go before the same judge
Yes.
again,
Yes.
and this time you would expect them to hold that it is maintainable.
सर फिर तो रिव्यू जुरिस्डिक्शन भी खत्म कर देनी चाहिए.
दूसरी बात है कि अगर ये
I
कानून
think there's a simple solution to this.
देखिए उसको सॉल्यूशंस ढूंढने से पहले जो मौजूदा निजाम है इस कानून को एक तरफ रख दीजिए. इस मौजूदा निजाम में कैसे होता है? देखिए साहब, इधर भी थोड़ी सी
Sorry,
जो दे दें कभी कभी.
नहीं सर, आप प्लीज शर्मिंदा पे शर्मिंदा.
नहीं तो आप वो देख कहीं और रहे
नहीं,
हैं, तो जरा ये देख लीजिए मौजूदा निजाम में अगर ये एक्ट तसव्वुर कर लें कि नहीं है बना, अब 184 की आई थिंग, अब तो वो ब्रांच में लिखेगा नॉट मेंटेनेबल, यही लिखेगा ना, या पुट अप कर देगा कोर्ट में या लिख देगा, फिर उसकी करेंगे चेंबर अपील. ठीक है, फिर जज कह देगा द ऑब्जेक्शंस आर सस्टेन्ड और ओवररूल्ड. तो ये कहना कि ये जो निजाम आया है ये मौजूदा निजाम से खराब है तो एक अलग बात है.
नहीं, ये मौजूदा निजाम से बहुत बड़ी इम्प्रूवमेंट.
अभी तो वो इख्तियार सारा उसके पास बैठा हुआ है, वो रजिस्ट्रार खुद भी नहीं कर रहा है, वो कोई सब डेलीगेटेड पावर एक्सरसाइज कर रहा है, जो पता नहीं जो पिटीशन एंटरटेन कर रहा है. ठीक है, और वो बहुत से लोग शायद अपील भी ना करें, वो भी चेंबर अपील है, वो अगेन वही अब वही जज अगर चेंबर अपील में उसने सपोज किया वो कल बेंच में बैठ सकते हैं, क्योंकि वो एक और चीज तरह की नजर से देख रहे हैं, अब बेंच में बैठ के दूसरी नजर से देख रहे हैं.
All cases which go through scrutiny should be put up before a judicial bench. What is the issue?
फैसल साहब ये बताइए,
What is the issue?
फैसल साहब जी ये बताइए, क्या जो इसकी डिफिकल्टीज यहाँ पे अभी हाईलाइट हो रही हैं, आर वी empowered under Article 191 to amend our rules accordingly, remove these difficulties? The power vests in us.
बिल्कुल.
So there, I don't see any
I don't
difficulty or problem
see
in this.
how this provision is a threat to the independent. If all cases after scrutiny are put before a judicial bench.
Mr. Faisal, यहाँ पे एक चीज और क्लैरिफाई कर दीजिए. 191 के तहत अगर फुल कोर्ट की मीटिंग कॉल करनी है तो किसने कॉल करनी है? Where it is written? Who will call the full court meeting?
So that is to be called by the Chief Justice.
It says the committee now.
Where it is written?
So this is the practice.
Committee will, including meetings and constitution of benches with the committee now.
Sir, वो full court meeting की बात कर रहे हैं, not the constitution of benches.
तो इसका मतलब
Sir, that is the practice, your lordship.
नहीं तो practice तो यही है ना कि that is to be done by the
Other
Chief
judges
Justice.
can call the meeting and amend the rules.
Yes.
Can they do it?
Sorry?
If the Chief Justice doesn't want to amend the rules, then the other judges can call the meeting and amend the rules.
Sir, these are very difficult questions which I need to really think
आपके
about.
सामने एक सिचुएशन चीफ साहब ने रखी है
जी बिल्कुल.
कि अगर मैं केस फिक्स नहीं करता तो क्या रेमेडी होगी आपके
सर
पास?
मुझे इन सवालों
The other judges would be silent spectators. Can they call the convene the
ये
meeting?
conflicts है within judges, इनके बारे में
इसका जवाब इसी लेजिस्लेशन में दिया हुआ है. 2 सबसेक्शन 2 पढ़े.
वो कमेटी की मीटिंग है.
फिर वो कमेटी, वो कॉन्स्टिट्यूशन ऑफ बेंचेस
इससे ऊपर जब शुरू करेंगे तो उसमें कौन सी चीज रह गई है? एवरी कॉज अपील मैटर बिफोर
एडमिनिस्ट्रेटिव साइड पे
सब कुछ हो जाएगा.
नहीं सर, ये जुडिशियल कॉन्स्टिट्यूशन ऑफ बेंचेस हैं, उनका सवाल
वो सवाल ये है कि इसमें कौन सी चीज है जो इसमें की गई है.
Sir, I wouldn't like to read matter as involving full court meetings.
ना ये पहली दफा सिचुएशन अराइज हो रही है, जैसे अभी पॉइंट आउट किया गया, तो उसको हम एग्जामिन कर रहे हैं, तो वी नीड योर असिस्टेंस. व्हाट इज योर व्यू पॉइंट?
फुल कोर्ट कॉल करने का तो वैसे भी रूल्स में तो कोई प्रोविजन नहीं है.
कोई प्रोविजन नहीं.
बिल्कुल नहीं.
This is practice.
देखिए साहब,
जी
लाइटर नोट, इतने पैसे क्लाइंट ने नहीं दिए.
अब मैं अपने आप को शर्मिंदा नहीं करना चाहता. These are very difficult questions, my lord. I really have to think about that these conflict within judges, how are those to be resolved, whether writs are to be issued, what are the other mechanisms. These have no easy answers. मुझे इस केस के ऊपर सोचते हुए इतने हफ्ते लग गए. I think what your lordships are taking will take me 6 months to really think about.
मिस्टर सिद्दीकी, हमने सुना you're a sportsman. कभी कोई टीम ऐसी देखी है जिसके 3 कप्तान और वो जीती हो?
And Mr. Siddiqui, you can ask for the in-camera proceedings.
वैसे सिद्दीकी साहब, स्पोर्ट्स से मेरा भी ताल्लुक है. कप्तान और वाइस कप्तान जरूर होते हैं.
सर सुप्रीम कोर्ट में होपफुली कप्तान नहीं होना चाहिए. Sir, let's move on. I'm just running through.
सिद्दीकी साहब, कैप्टन एक ही अच्छा लगता है.
Sir, Section 4, sir. Section 4 says that whenever an interpretation of constitutional provision is involved, a bench should not be less than 5. I think
That is again a dictation.
my lord, I mean it is.
Shall not be.
Lord, it's.
Why can't the committee say, well, this is an important matter?
But how will that affect? If there is a substantial question of
I
law,
I don't have a question of how will it affect. All along my question is, who is saying it? Who is constitutionally competent to lay down this principle?
If
this rule can be laid down by the court in its rules, and
if Parliament has legislative,
in terms of its rule-making powers under 191.
Sir, if Parliament has legislative power, then your lordship has to see whether this rule violates a principle.
That's a big if.
Yes. If Parliament has no legislative power, then this law goes, this provision goes. Otherwise, one looks at this provision.
Mr. Faisal, according to you, the Parliament has the legislation.
Yes.
Move on. According to you, Parliament has the power. We will decide whether Parliament has power or not. Not move on.
ये clarity इसमें सिर्फ ये
if the Parliament, if we come to the conclusion that yes, of course, Parliament has the power to make a law, then in law the Parliament may use the word may or may use the word shall.
But even Parliament cannot make a law which will destroy the power of the Supreme Court to make rules and violates the independence of the court.
Okay, so tomorrow the Supreme Court full court says, well, we think 5 judges are not enough, or 5 judges are too much, we want to make it 3. Can they do it?
No. In terms of this,
according
in
to
the
you,
presence of this law, they cannot.
Yes.
Yes.
So that means a power of this court has been trumped by legislative instrument.
Sir, the question should be what fundamental rights or independence of the judiciary has been violated. The only thing was that it's a bit badly drafted. The term is actually a substantial question of law involving interpretation. यही term use हुआ है Article 185(2)(f) में.
यही term देखिए कोई नई बात करें तो फिर दूसरों को सुनने
एक सेकंड, एक आपने दिया 3 को रीड डाउन कर दें,
सिर्फ 3 को,
ठीक है. 4 is badly drafted. अभी हम 4 पे आए हैं, अभी आगे 5
Sir,
you have an uphill task.
No, but sir, the point is, this is, has ever a law been struck down because of bad drafting?
No.
Or being impractical?
A law can be struck down on various grounds.
Yes.
One of which is, it is vague, it is unclear, it is
not
beyond,
on bad drafting.
It is beyond legislative competence.
But not on bad drafting. अब एक criminal lawyer ने ये law बनाया तो वो constitutional problems तो कुछ होंगी sir. Sir, section 5 sir.
Is that a confession?
You are saying it behind his back.
Sir, मुझे तो यही समझ में आता है.
नहीं ये ना करें.
Now I come to the main question, which is this problem of a full court and there being no appeal, and the problem that if there are 8 or more, if there are 9 judges, there would be no appeal.
नहीं मगर इससे पहले तो आप ये तो आपने गिवन कर लिया प्रॉब्लम है. देखिए ये ऐसे ना अप्रोच आप देखिए मौजूदा सूरत हाल में बेहतर थी खराब थी, ये तो कहना ये प्रॉब्लम है कि फुल कोर्ट हो गया तो अपील नहीं है, तो फिर आप इस कानून
इसका जवाब दे रहा हूं.
नहीं जवाब नहीं होगा, ये क्वेश्चन हो ही नहीं सकता है. मैं बता रहा हूँ क्यों नहीं हो सकता है. सवाल इसलिए नहीं उठेगा,
सवाल तो
जरा सुन तो लीजिए ना, आप कोशिश कीजिए ना. मौजूदा सिस्टम क्या है, इस कानून को एक तरफ रख दीजिए, आप जरा तवज्जो दीजिए.
जी जी.
मौजूदा सिस्टम ये कि इस कानून को 1 मिनट एक तरफ रख दीजिए, ठीक है. अब कौन सी अपील है ही नहीं ना. तो अब आप कह रहे हैं ये कानून जो आया है 99% खामियों और रिपोर्टेड खामियों को दूर करने के लिए, वो इस लिहाज से बुरा है क्योंकि वो 1% केसेस जिसमें फुल कोर्ट होगा कोई अपील नहीं है. तो पहले तो फिर अगर आपका ये बात मान ली जाए तो आप फिर तो आप ये कह रहे हैं, आपकी बात में ये इम्प्लाइड है कि ये कानून दुरुस्त है. अब आप 1% के लिए भी अपील प्रोवाइड कर दें तो फिर ये निकलेगा, या तो आप कहेंगे कि जी 99% तो मसला सॉल्व हो गया, 1% करेंगे.
मैं यही बात कि the mere fact that there isn't an appeal in certain category of cases would not make the law unconstitutional.
They may most certainly be a difference of opinion. One person can think that this is not relevant, but I think that it is very relevant, because when the law gives a right of appeal and the committee has the option of taking that right of appeal away, then it is relevant to the person whose right of appeal has been taken away. If we recognize appeals as being substantive, then that so-called arbitrariness that is being controlled, I don't see how it's being controlled, because किसी को right मिलेगा, किसी को right नहीं मिलेगा. Again the question will be ये कैसे decide होगा. Again we'll go looking and hunting for principles, कि कौन सा principle apply करें. So on the face of it, it means that either you can't ever constitute a full bench, you can't constitute a bench which is more than 7 or 8 members, that's it. You're not allowed to do that. Because Parliament has said appeal होनी चाहिए, और appeal होनी चाहिए का मतलब है that every order of the Supreme Court under 183 has to have a right of appeal. It doesn't mean that I have the option to choose कि अब full court बैठ गया तो सब अब कोई फर्क नहीं पड़ता क्योंकि सब ने केस सुना. Right of appeal is a right of appeal, which we've heard at length yesterday, how we recognize that right of appeal, how Islam recognizes that right of appeal. So यहाँ कैसे हम वो right ले लेंगे वापस and कहेंगे नहीं यहाँ नहीं है क्योंकि हम सब बैठ गए.
So Faisal, if you look at the, I mean, to me it appears to be an intra-court appeal.
Yes.
So if the High Court, if the larger bench is constituted, there's
Yes.
intra-court appeal.
Sir,
So if there's a larger bench, there's no appeal.
There are 3 restrictions on an appeal from a single judge in an inter-court appeal.
अच्छा ये इसमें एक और बात अगर आप मद्देनजर रखें, हम अगेन realm of conjecture
सिंगल बेंच इस वजह से जब डीबी सुनती है या 3 जज सुनते हैं तो इसलिए उसकी अपील नहीं जाती. लॉ रिफॉर्म itself provides an answer. The appeal provides where a single judge decides the question.
जी मैं
1 मिनट आता सर जी.
देखिए हम कंजेक्चर समाइज पे भी बात कर सकते हैं. अब आप बताइए आखिरी इस फुल कोर्ट से पहले कौन सी फुल कोर्ट थी?
I think 2015 सर.
कितने साल गुजरे?
जी 8 साल हो गए.
तो हम उस केस के लिए सिर्फ फिक्रमंद हैं या हम फ्यूचर के लिए फिक्रमंद हैं? 2 बातें हो सकती है ना. एक तो पिछले के लिए हम फिक्रमंद हैं कि वो केस में वो जो 21वीं अमेंडमेंट टू द कॉन्स्टिट्यूशन है वो एक राइट ऑफ अपील सलब हो गई और वो नहीं हो सकती है. ये एक मफरूजा हो सकता है. ठीक है. दूसरा है कि नहीं हम पिछले के लिए फिक्रमंद हैं तो हम फ्यूचर के लिए फिक्रमंद. फ्यूचर की जब बात आएगी, जब एक्चुअल बात आएगी हमारे सामने, फिर हम अगर आप हमें इतना रिस्पेक्ट देते हैं कि हम आपस में कुछ समझ लेंगे इसको. हमें ये तो नहीं बताना है कि फ्यूचर में क्या होगा. हमारे सामने जो मसला आता है और हमेशा ही कहा गया है उसी मसले को हल करो जो आपके सामने आ जाए. अब क्या मसला होगा आइंदा, हो सकता है कभी फुल कोर्ट हो सकता हो जाए, तो जब वो मसला आएगा फिर आपको सुनेंगे कि फुल कोर्ट बैठना चाहिए, 7 मेंबर बैठना चाहिए, 10 मेंबर बैठना चाहिए, वो सारे बातें इशू खड़े हो जाएंगे. अभी तो फुल कोर्ट एक ही बैठी थी, मुझे जहां तक याद है, आपकी बात सही है, 2015 में 21वीं अमेंडमेंट की बात. उसके बाद तो फुल कोर्ट नहीं बैठी. तो ये आई है दूसरी दफा
My answer to the question. This is one way of
When legislation is framed, the legislators are supposed to look at all eventualities and try as far as possible to cater for them. Now it is so obvious that there is this defect in this law. Was it debated? Was it thought about? Was there a thought process? And thereafter it was drafted keeping in mind कि जी full अगर court hearing करेगा तो उसकी नहीं होगी. And if it was thought about it, why was it not mentioned in the
my response would be
the obvious conclusion is that there is a flaw. And
there is no flaw.
Is so apparent.
There is no
that
flaw.
Everybody can see it.
No, there is no flaw. It's a self-contradictory question. When you say that there should be an appeal in the full, no legislature in the world can provide an appeal.
Nobody is saying that there should be an
There
appeal.
can never be an appeal to the Supreme
You
Court.
have actually
There can
misunderstood.
never. It's a
No, Mr. Siddiqui,
self-contradictory
the question is not whether there should be an appeal in the full court. The question is simply that how will this right of appeal be exercised if you cannot constitute a larger bench because you have been stopped from doing so. Which means that when a full court, if the he decides, whereas in this case, where a full court is sitting, if this law is upheld, that there is no right of appeal. So the question is simply this: that आपने
right of appeal.
block कर दिया ना right of appeal. What is the point of giving that right?
कोई legislature दुनिया का appeal दे ही नहीं सकता.
There is another aspect to it.
But I come to the 9 judges thing.
Actually, there is no answer to this question.
No, there is.
Go around and put a full stop to it कि जब full court में हम बैठ के यानी कि हमने जब decide कर लिया full court तो then there is no right of appeal.
ऐसी चीज की deprivation किस तरह मांग सकती है? तो वही नहीं.
You have deprived someone something that the lawmaker thought was essential.
No,
it's not a problem at all. It's not a problem at all.
But मैं कहता हूँ अच्छा ये 9 member की
ये देखिए
एक सेकंड
सेक्शन 5 में लिखा हुआ है, सेक्शन 5 पढ़िए,
जो पावर है
राइट ऑफ अपील का
तीन जजेस की कमेटी को दे दिया कि किस में वो राइट ऑफ अपील देंगे और किस में नहीं देंगे.
सर मैं उसका जवाब दे
Is
दूं?
that correct?
मैं उसका जवाब दे देता हूँ. देखिए, full court I don't think even a right of appeal can be demanded. Now the issue is that in cases.
So no, where does the law say that?
Sir, it is an impossibility. You cannot provide 50 जज भी हो जाए कि आप full court की अपील किस तरह?
लार्जर बेंच बन नहीं सकती ना. देखिए सदीकी साहब,
the point that it has not even.
देखिए साहब देखिए इसमें
It has not even been
अपील में ये बताया गया है कि the appeal should be heard by the larger bench. ठीक, लार्जर बेंच के नंबर्स नहीं बताए कि क्या एक जज मजीद बैठ के लार्जर बेंच होगा, 2 जज मजीद उसमें
लार्जर बेंच तो हो ही नहीं सकती ना. इसका जब फुल कोर्ट हो गया तो लार्जर बेंच और अपील.
सुन ले, लार्जर बेंच की प्रोविजन भी हो सकती है अगर ऐसी सिचुएशन आए.
It's a matter of interpretation by the court and it's sort
ये
of.
हम रूल्स में देख सकते हैं. इवन कॉन्स्टिट्यूशन में जरा, इवन कॉन्स्टिट्यूशन हमें ये इजाजत देता है whenever there is need, as per the constitution, a judge of any high court can be called for a particular case. तो लार्जर बेंच बनाने
So इसमें भी हम रीड इन कर लेते हैं. ये इसमें भी हम रीड इन कर लेते हैं कि ऐसे करना ऐसे करना. So आप 2 प्रोविजंस हो गए रीड इन, एक होगी बैडली ड्राफ्ट, ऐसे ही करते हैं.
रूल्स में कर सकते हैं.
Rules cannot read down something which the legislature could never do.
मिस्टर सिद्दीकी, आप रिडंडेंसी तो इस अपील में रिडंडेंसी तो नहीं एट्रीब्यूट कर सकते ना. आपने अपील प्रोवाइड करनी है
नहीं,
एंड इन ऑर्डर टू अवॉइड रिडंडेंसी. अच्छा
नहीं करनी. बट लार्जर बेंच का मतलब ये फुल कोर्ट के ऊपर अपील नहीं होगी.
आगे बढ़े, आपका सुन लिया.
Let me complete. In order to preserve that right, in order to preserve the right of appeal, in essence, you can never constitute a full court.
Sir, because full court पे अपील हो ही नहीं सकती, तो you can always constitute a full court.
In that case, there will be no appeal.
आगे बढ़े.
सर
आपका मौके सुन लिया, हमने कहा नहीं हो सकती.
सेक्शन 2 रेट्रोस्पेक्टिविटी का इशू था. ये अपील दे दी गई है रेट्रोस्पेक्टिवली. सर, there are two principles which will radically reduce the right which have been given. The first was pointed out by Justice Athar. This is an appeal against orders passed under Article 184(3). If an order has been passed after that under review jurisdiction, the appeal will not lie. These orders which, that's the first thing.
Then wait a second, does the law say this or this is your interpretation of the law?
Sir, 184(3) के orders है ना. अगर आपने review file कर दिया, उस पे review का order आ गया.
188.
अगर किसी को अभी किसी का review pending है and he wants to really have the right of appeal, he has to withdraw his review.
I mean, you see, there is no cut-off date of filing appeal. There is open-ended.
There is a cut-off date for filing appeal.
Mr. Siddiqui,
just
वो सिचुएशन देख लेंगे ना.
सर, सेकंड प्रिंसिपल मैं बता दूं. सेकंड प्रिंसिपल,
सर ये आप मफरूजों पे जा रहे हैं. वो what may or may not happen, but just tell us. देखिए, surely it boils down to one thing. Some of us think the law should be struck down because the right of appeal is not been extended to what will happen to the scenario when there's a full court. ठीक है, others think it doesn't matter. Fine. I'm just saying, can you strike down a law creates a right of appeal, but it is to be struck down only because in one given scenario there is no right of appeal.
And sir, no law can be struck down on the argument of floodgates. No law can
अब आगे बढ़े ना, आगे बढ़े.
The second restriction is that in every retrospective law, your lordships have said that this retrospectivity will never apply to closed and past transactions और वो vested rights have accrued. Sir, 103 के 1% से कम केसेस होते हैं.
आप बात सुने,
आपने रिव्यू निकाल दिया, आपने vested right निकाल दी, closed and past
transactions,
कितने केस बच गए?
कल ये आर्ग्यूमेंट हुआ कि इसको आप रीड डाउन कर लें, and it actually means 30 days. Within 30 days of filing of the promulgation of this act, जो decisions आए हैं या before उसके आए हैं within 30 days, तब से वो limitation start होगी. लेकिन 1973 से या 1974 से नहीं होगी. ये भी आर्गुमेंट आया और हमने नोट किया.
Sir, I'm not arguing. There is nothing wrong with this provision if these two principles are.
All right.
I'll move on.
Mr. Siddiqui, 184(3) is a constitutional provision.
जी.
It is original jurisdiction.
जी sir.
appeal is continuation of the same.
Ji.
How a law which is legislative incompetence because of not being a constitutional provision that can be provided by a simple law-making power of the legislator.
I have extensively dealt, अगर आप note देख लीजिएगा उसमें. I just want to, क्योंकि बहुत वक्त हो गया है, अगर आप allow करें मैं जरा
simple बता दें आप.
It's your jerky motions that distracts judges. They don't get to concentrate on your arguments.
Sir, there is no bar under Article 184(3) that it bars that you can't create an inter-court appeal, and that has been done in other laws also. I mentioned two laws: the Law Reforms Ordinance, Constitutional Forum, appeal is provided.
It is an entirely different premises.
No, my lord, I think it is clearly, and that is what, when I had read the judgment.
It has been explained by Mr. Ijazul Hasan, and very thoroughly that has been explained.
My lord, I would beg to disagree. And then, of course, there is the appeal in the contempt of court order. But now I'll come to the most difficult part, and with the utmost respect to the benches, which is
incidentally for the time you have said, I now come to the most difficult part. So,
every section of this law
is so convoluted and difficult that
I have stated the reason why the law is so difficult.
Every section is the most difficult part of your argument.
The most difficult part is that one never wants to say that, Your Lordship, there is a judgment which should be revisited. There are two judgments, and they have been rightly cited by the petitioner's counsel, my lord. One is the Bas Kakar case, where they have relied on certain principles of law and constitutional principles, on the basis of which they seek the striking down of law. I will not go into the detail of the my lord. I'll just point out the pages. Page 1993 to 1995 deals with Section 8 of the Contempt of Court Act 2012.
ये कौन सा बाज मोहम्मद वाला है?
जी, PLD 2012 Supreme Court 923.
923.
Now, my lord,
इसमें
sir, 993 to 995.
Sir, 995 इसमें क्या खराबी है?
Section 8 in the Contempt of Court Act.
ये कितने जजेस का?
सर मेरे ख्याल में 5 दिखाओ बेटा, 5 नंबर
देने 1
2 3 4 5 थे सर.
अच्छा, इसमें ये पेजेस गलत हैं, क्यों?
नहीं, ये पेजेस गलत नहीं है, distinguishable है. The reason is that if your lordships looked at Section 8, which was struck down, of the Contempt of Court Act 2012, which I have attached in my notebook, वो ये करता था कि एक जज ने कॉग्निसेंस ले लिया है एक कंटेम्प्ट का, और वो ये कहता था कि ये ट्रांसफर कर दें. चीफ जस्टिस ने कॉग्निसेंस ले लिया और कहता था ट्रांसफर कर दें. So it was really interfering in judicial orders. Now, when it came to the appeal, what the Supreme Court has done is that it has said that Section 19 में जो appeal है वो ठीक है. Those are pages 1000. Those are pages. वो दिखाना मुझे, जजमेंट दिखाना. It's para 82.
पैरा 82. ठीक है, पैरा 82 ठीक है, कोई फर्क नहीं पड़ता है.
एक मिनट,
प्लीज बता दें.
प्लीज नाम बताइए.
1004.
ठीक है, पैरा 82 हो गया, हम ढूंढ लेंगे.
Para 82, and after striking down the 2012 Act, that law is revived. Now, the problem with the appellate appeals provision in the 2012 law was कि सर उसमें लिखा हुआ था एक अपील फाइल होगी, वो किसी शोकॉज के खिलाफ, हर किसी के खिलाफ, और फिर फुल कोर्ट बैठे सारे जज बैठेंगे. मतलब सारा पावर ऑफ कॉन्स्टिट्यूशन ऑफ बेंचेस ले लिया गया था, और उसमें लिखा था फौरन सस्पेंड हो जाएगी. So that was such an interference that, though whatever has been said,
but can't you reconcile it by simply saying that in that case the Parliament did something so extreme,
yes,
to protect people of a particular who may have committed contempt, Therefore, the court found necessary to intervene. Here, maybe that they have not done something so
Yes, and the
extreme.
law was, I think, unconstitutional. So, वो distinguishable है, provisions देख लीजिएगा. Now, I come to the judgment which, with due respect, I think if the law is to be upheld, this law has to be revisited to a certain extent. If your lordship may kindly see, sir, this is called the Ghulam Mohyuddin case.
Citation देते हैं.
Sir, ये unreported है. It is 11th August 2023.
11th August, ये कितने member bench है?
SMC के क्या नाम?
Three member bench. नहीं, this is constitutional petition number 21, 22, 23 of 20. मैंने लगाया है सर अपनी पेपर बुक.
ये कहीं रिव्यू वगैरह में तो नहीं पड़ा हुआ है?
Sir, this is in review also.
रिव्यू में फैसला हुआ है?
नहीं.
तो फिर इसको पता नहीं मुनासिब है या नहीं इसके मुताबिक.
Sir, there are passages in this
तो
judgment.
अगर इसमें देखिए, अगर हम फिर उसको रिव्यू को फिर रिडंडेंट बना देंगे.
Sir, वो बात, I think even if those passages are revisited, the judgment on its own would stand.
नहीं देखिए,
But there are passages.
नहीं फैसल सिद्दीकी साहब, दो बातें हैं. पहली बुनियादी बात है, अगर एक वो रेगुलर उसमें आया है हमारे पास रिव्यू में, जो राइट एक्सरसाइज है, उसको हमें बात नहीं करना चाहिए. अब जहां तक असूल की बात है, अगर इस केस में जिस तरीके से भी फैसला किया, असूली फैसला किया, अब उसका शायद असर उस पर पड़े या ना पड़े, वो तो एक अलग बात है, क्योंकि नहीं वो हम देखें, उधर जाने नहीं चाहते हैं, तो इस केस का जिक्र ही ना करें बेहतर.
My last point and then I will conclude, sir. Page 8.
One thing I need to add. This law, which is under challenge now, was promulgated on the 21st of April 2023. Or review of judgments law immediately after that, which is 26th of May 2023. And if you go through, compare both laws, they are a repeat of each other almost, except that in review they said कि जी review में वही grounds होंगी जो appeal में होंगी. And it was pointed out to
सर वो पोएम थी ना, try again, वो
उसका क्या बना?
Okay, you answered that.
उसका केस
You answered my question. Try again. There was so much desperation.
नहीं, वो सेटिस्फाइड हो गया
जी.
उसमें भी रिव्यू है या नहीं है?
नहीं, ये वाला रिव्यू वाला तो
नहीं, ये जो दूसरा
नहीं, ये उसी की बात कर,
उसमें भी रिव्यू हुआ है या नहीं?
जी नहीं सर, उसी की बात कर रहे हैं, उसी की बात की.
अच्छा, इसी में?
जी.
अच्छा ओके.
इसमें जो एक और केस हुआ, जी ये सब्सिक्वेंटली आया.
सर, लास्ट पॉइंट which is page 8 of my note.
Whether last point is difficult or easy?
नहीं सर, ये सबसे आसान है. This might actually unite the court. Sir, if your lordship comes to the conclusion that any part of this law, let's say section,
don't throw the baby out with the bath water.
Sir, ये सारी जो प्रोविजंस है अगर आप देखेंगे तो इंडिपेंडेंट है. सिर्फ 3 और 4 का ताल्लुक है 2 से, और किसी का ताल्लुक नहीं है. 3 or 4 refers to the committee in section 2. Even section 2, if it's upheld, and section 3 and 4 are not upheld, it will not make a matter. So if your lordship comes to the conclusion, I hope your lordships and ladyships, but then the doctrine of severability can be applied in this case. It couldn't have been applied in the 2012 case. I'm very grateful to your lordship for a very patient hearing, to all your lordships and to your ladyships.
Thank you. At least speaking for myself, I compliment you for answering or trying to answer all the questions to the best of your ability.
Thank you.
You were well prepared.
Thank you, sir.
I'll add my voice to that.
You must thank us also. We made exercise, lose calories.
Thank you, sir. Thank you. Very kind, sir.
अब कितने लोग रह गए? बता दें कौन कौन से हैं. कोई जो मुख्तसर वाले हैं, किसी ने आप कोई नई बात, क्योंकि काफी तफसीली आपको फायदा मिल गया. जाहिद इब्राहिम साहब और कौन थे, फैसल सिद्दीकी साहब का.
इसमें सबमिशन यही थी कि हमने प्रेस रिलीजेस भी इशू किए थे, रेजोल्यूशंस भी थी कि फुल कोर्ट की कंस्टिट्यूशन हो.
वो तो हो गया
माय लॉर्ड,
बगैर आपकी प्रेस रिलीज पड़े हुए.
माय लॉर्ड, अच्छा, वो हमने सीएम लगाई हुई.
नहीं तो आपने जो बातें अगर लिख दी हैं तहरीरी तौर पे तो वो हम पढ़ लेंगे, अगर आपको कुछ मजीद कोई खास पॉइंट रह गया है जो इनसे छूट गया है तो बता दीजिए, नहीं तो काफी अटॉर्नी जनरल मेरे ख्याल में मेन आदमी शख्स होंगे।
इसमें सबमिशन यही है कि जो एक्ट पास,
आप इसको सपोर्ट कर रहे हैं।
मस्ट। अच्छा, एक्ट पास हो गया।
तो ये बताइए कि क्यों डिवीजन क्यों आया है वकीलों में? पाकिस्तान बार काउंसिल एक मौक़िफ़ ले रहा है, सुप्रीम कोर्ट बार एसोसिएशन दूसरा मौक़िफ़ ले रहा है, ये काफी एक कानूनी बहस है।
लेकिन इससे पहले सुप्रीम कोर्ट बार ने जो रेजोल्यूशन और अपनी प्रेस रिलीजेस दी हुई हैं वो इसी पर्पज के लिए दी हुई है। वो अगर इजाजत हो तो मैं पढ़ लूँ। माय लॉर्ड,
आपने फाइल की हुई है?
माय लॉर्ड,
नहीं, हम देख लेंगे। अगर फाइल है तो ठीक है। अब ये आपका सीएमए नंबर से बता दें।
इसका आसान जवाब ये है, रीजनेबल माइंड्स कैन डिफर।
यस माय लॉर्ड। और इसमें सबमिशन यही है,
रीजनेबल माइंड्स, वो आप अपना सीएमए तो बताइए नंबर। पाकिस्तान बार काउंसिल ने क्या फाइल किया?
माय लॉर्ड 4207 8087
एक सीएमए नंबर
और 8087।
सॉरी, दोबारा आहिस्ता कहिए, एक शख्स बोले
जी। 420 पहले ये अलाउ हुई है और 80
तो हो गई फुल कोर्ट। हाँ, अच्छा, ओके।
8087
दूसरी कौन सी है?
8087।
8087। हम आपको कब खत्म नहीं करना चाहते, मगर अगर वो बातें हो चुकी हैं, वो दोहराने वाली बात नहीं है तो फिर रहने दें।
मतलब इसमें सबमिशन सिर्फ इतनी थी कि जो एक्ट पास हुआ है उसमें सुप्रीम कोर्ट की पावर्स को इनलार्ज किया गया है, उसमें कर्टेल नहीं किया गया। और उसमें अगर एक जज के पास ये इख्तियार था तो वो अब 3 जजेस साहबान के पास इख्तियार आ गया है। और अगर वो विद द कॉन्सेप्ट जिस तरह कुरान में भी है कि मशवरे के साथ अगर किया जाए, इसलिए कि पहले मशवरे नहीं होते थे, तो जिस वजह से हमने और सुप्रीम कोर्ट के फैसलों में हमने सफ़र किया है और ऐसे ऐसे फैसले भी हुए हैं जो कि सुप्रीम कोर्ट के जजेस साहबान ने, जिस तरह जुल्फ़िकार भुट्टो केस है उसमें नसीम हसन शाह खुद एडमिट किया था कि जो ऑर्डर हमने किया था वो हमारी गलती थी और कोई प्रेशर था। तो इसलिए मेरी सबमिशन ये है कि ऐसे ऑर्डर किए जाएं कि जिस तरह आर्मी चीफ को ये भी इख्तियार दिया जाता है कि वो प्रेसिडेंट भी बने और आर्मी चीफ भी रहे, और 4 आर्मी चीफ जो हैं वो हमारे प्रेसिडेंट भी रहे इन यूनिफॉर्म। और इस बात का तल्लुक कोई किसी कॉन्स्टिट्यूशन से नहीं है। किसी कॉन्स्टिट्यूशन में ये मेंशन नहीं है कि एक आर्मी चीफ होगा और वो सेट और वो इलेक्शन लड़ेगा और प्रेसिडेंट ऑफ पाकिस्तान बने। इसलिए ये हमारी खुशकिस्मती है
कि इंडिपेंडेंस ऑफ जुडिशरी पे इसका कोई असर नहीं, बल्कि
मतलब डेफिनेटली इसलिए कि प्रीवियसली जुडिशरी ने इंडिपेंडेंस व्यू नहीं दिया, इसलिए कि कॉन्स्टिट्यूशन में एक इख्तियार है ही नहीं है, तो वो भी दिया गया। और उन्होंने
आप क्या कह रहे हैं कि अपील का हक देकर के इंडिपेंडेंस ऑफ जुडिशरी बढ़ती है, कम नहीं होती है?
बढ़ती है माय लॉर्ड।
अच्छा,
इसलिए कि अगर वो राइट दिया गया है, अगर एक जज साहब के फैसले से कोई सफर करता है तो वो 3, 5 और 9 और इस तरह सुने।
आजाद अदलिया।
तो इसलिए मेरी सबमिशन ये है कि जिस तरह प्रीवियसली हो गया है कि जफर अली शाह केस है उसमें फुल बेंच ने ये ऑर्डर फरमाया हुआ है कि आप चीफ एग्जीक्यूटिव ऑफ द कंट्री भी हो गए, आप कॉन्स्टिट्यूशन भी अमेंड कर सकते हो और आपने राइटली एक पॉलिटिकल और डेमोक्रेटिक गवर्नमेंट को डिसॉल्व किया। तो इस तरह के अगर होंगे तो हम आगे फ्यूचर में नहीं चल सकेंगे। मेरी सबमिशन सिर्फ इतनी है कि फैसले ऐसे किए जाएं वो जो कौम को और दुनिया को नजर आए कि वो जुडिशरी ने फैसले।
तो आप समझते हैं कि इस तरह हो कि आजाद अदलियत तो हो लेकिन कानून और आइन के पाबंद हो?
आइन की पाबंद। ठीक है, थैंक यू। यही मेरी सबमिशन है।
ठीक, शुक्रिया। आपको कितने लोग रह गए?
आर्ग्यूमेंट्स हो तो ऐसी।
Is it short or is it long?
I'll try to be short. Already had audience on the first hearing. I have filed written submissions and additional submissions, but I'll try to conclude my submissions in 1 hour, not more.
Who would leave you to conclude your arguments in 1 hour?
Not so.
You will become bored with questions now.
You can't get away that easy. No.
I said 1 hour for me.
कल आप हैं इधर?
I am.
कल को मेरा केस तो नहीं है कोई बड़े वाले कोई बंचेस रखा था ना बहुत बड़ा? हाँ, तो कल फिर में आप भी जरा फ्रेश हो जाएं, हम लोग भी जरा फ्रेश माइंड्स के साथ बैठेंगे। अगर आपको अगर you're here, you're not.
I've noticed that in the first half an hour one can get away with questions and make substantial progress.
You're going to regulate us.
Today I noticed that.
Are you going to regulate us? Are you going to tell us? We are going to conduct ourselves.
I'm just hoping this is an expectation.
It's a hope against hope. It's not going to happen.
Regulating the Supreme Court appears to be the one thing these days.
Flavor of the day.
Okay. अच्छा आ गए सर रिश्ते आ गए कहती ना रिश्ते आ गए जी हाँ सॉरी ऑर्डर भी डिक्टेट ही कर दें आपके सामने थैंक यू फॉर रिमाइंडिंग 2 मिनट ठहरिए क्योंकि गलती वगैरह हो फिर आप हमें करेक्ट कर देते हैं इसमें लिखिए इन सपोर्ट ऑफ द एक्ट मिस्टर फैसल सिद्दीकी नहीं एम क्या असली नाम क्या है आपकी पार्टी का किधर गए वो
मुत्तहिदा I think it's MQM मुत्तहिदा कौमी मूवमेंट
अच्छा
मुत्तहिदा कौमी मूवमेंट
मुत्तहिदा कौमी मूवमेंट पाकिस्तान या कुछ तो नहीं लिखते हैं ब्रैकेट में कर दें MQM is represented by Mr. Learned Mr. Faisal Siddiqui, who during the course of arguments submitted a booklet and said he had not filed anything else. Full stop. He semicolon. He concluded his submissions. Whereafter, आप उनके नाम लिख दें पाकिस्तान बार काउंसिल के वाइस चेयरमैन एंड
वाइस चेयरमैन एग्जीक्यूटिव कमेटी
और आप अच्छा ठीक है stated that they stated that they filed 2 applications. The first CMA number 4207/2023, which sought the constitution of the full court as structures in the full court is hearing this case, and their contentions are contained in the other CMA 8087. Full stop. आप इनके submissions adopt करते हैं या नहीं? They further state that the submissions made in support of the act they adopt and don't want to repeat for the sake of क्या होता है? To avoid repetition. ठीक है. Learned Attorney, it is now almost 4 p.m. Learned Attorney General states that he will take about an hour to conclude his submissions. Adjourned to कल तारीख Tuesday, Wednesday, 11th October 2023 at 11:30 p.m. here. Yes. I'm tired. Why not just as well. Uzair Saab ji. By the way, it's been a pleasure to hear you also.
My lord, I am so grateful, ji. I am so grateful. My lord, sir, a request thi ji, and I hope all council will join me in that request. Each one of us has been assisted by our colleagues and associates. If their attendance could also be marked in
on one names. Condition, all of you give affidavits that you have properly remunerated them also. Hello, for the
certainly my firm has my firm has.
I'm more interested in safeguarding the interest of the youngsters.
My lord, I am more interested in it than your lordship, and I can assure you of that.
चलिए ये अच्छी बात है.
We take good care of ours. So ये मेरी एक request थी जी.
वो आखिर में लिखें या अभी लिखें?
जब main judgment में जब
tomorrow's order
लिख के
अब ऐसा करें कि अगर वो हम अभी तो ये छोटे छोटे ऑर्डर्स है ना, इनको पता पूरा दिन लग जाएगा उनको नाम लिखने में.
आपके स्टाफ को मैं नाम दे के
नाम सारे दे दें,
नाम दे दें.
वो जब
मतलब आप तो एक नाम देंगे ना हर आदमी, नहीं कि 50 लोगों के नाम पूरी फॉर्म के लिख दें.
सर मेरे जी एक दो
आप देख लें, फिर हम देखते हैं कैसे होता है, कितने नाम आते हैं. ठीक है, आप लोग सब दे दीजिएगा.
ठीक है.
That we may or may not depend on all of us, incorporate them in the.
ठीक है सर, मेरी रिक्वेस्ट थी, बाकी आप देख लें.
Let committee.
No, let the master of the rolls. Thank you, everyone.
Grateful, sir. Great. Judgments of the court which I will refer to. That is all, my lord. If your lordship may kindly, and what I have done, my lord, so that I save your lordship's time, that I framed the questions on which I will address your lordship.
बताइए.
Precise questions which I framed. if your lordship may kindly see, after the index, page 1. For your lordship's convenience, I'll just read through the questions and then I'll make my submissions.
If you read the question and answer at the same time, it will be better.
Okay. So what I'll do, my lord, there are basically these questions which I framed. Basically, I'll make submissions, my lord, on these 4 or 5 broad propositions. I will not question the maintainability of these petitions. I think the petitions are maintainable, my lord. What I will be arguing that they should be dismissed on the merits and the law should be upheld as constitutional. But I don't question the maintainability of these petitions, my lord. Number 2, my lord, I'll stick to constitutional arguments, my lord. I will not go into the background of this law, and I'll stick to the questions which your lordships have addressed. The primary question which your lordships have addressed is one of legislative competence. And I see that question as having 3 parts. The first part of that question deals with the legislative competence to legislate on practice and procedure. The second part relates to the legislative competence relating to a direct appeal to the Supreme Court through an ordinary statute. And of course, connected to that is the question which I've stated in the second, but it actually has 2 parts. One is that where does the legislative competence come to legislate regarding an appeal to the Supreme Court, and connected to that question is whether that appeal can be provided through an ordinary statute or does it require a constitutional amendment. So these are these 3 broad questions. But I think the central question which is before your lordship is whether what is the relationship between the rules and the Act? Are the rules subordinate to the Act? Are the rules at par to the Act? Are the rules, can the rules override the Act? And as I would be submitting before your lordship, that I think none of these 3 scenarios apply. At times the rules will override the Act, and at times the rule will be subordinate to the Act. So I will place before your lordship this 4th option. My lord, then what I'll do is I'll move on to each of these sections. And there are precise questions which your lordships have raised regarding the various clauses and their constitutionality and problems. So I'll take your lordship through each of these sections, from section 2 to section 7. And in the end, my lord, I would like to address your lordship regarding 2 judgments. My lord, I think there are 2 central judgments which the petitioners have relied upon as legal precedents for the principles of law and constitutional principles which the petitioners have placed before your lordship. One is the Kakar case, PLD 2012 Supreme Court. And the other is a recent judgment of this court, the Ghulam Muhyiddin case. Now, if the petitioners are correct in terms of their reading of these judgments, then in terms of these judgments, this law would be unconstitutional. So my submission on this legal precedent would be crucial. I'll be making the submission that as far as the Bas Kakar case is concerned, PLD 2012 Supreme Court, that is clearly distinguishable in terms of the law which was involved, the Contempt of Court Act 2012. But as far as Ghulam Muhyiddin case is concerned, which concerned the Review Act which was part, I would be respectfully submitting before your lordship that parts of those judgments have to be revisited. Not the entire judgment, but parts of that. My lord, let me come to my...
have to be
revisited. But only parts of that judgment, my lord. My lord, if I may take your lordship to my first submission. And my first submission, as his lordship, what I've done is that I framed the questions and then I framed short answers and then I'll make submission. Let me just read the question. The first question is, and this is a question I think which has been troubling her ladyship, Justice Aisha Malik, whether the term law occurring in Article 191 Constitution 1973 includes acts of parliament. whether the term law occurring in Article 191 itself confers legislative competence and or requires legislative competence to be based on some other provision of the Constitution and or legislative entry in the 4th schedule. If the Parliament has the power to enact a law, enact such a law, then what are the limitations of such a law? My Lord, if your Lordships may turn to the 3rd page of the brief note which I have given your Lordship, and the heading is B, where I deal with this question. Now, my Lord, the term subject to law. Now, question has occurred and repeatedly been asked, is this conferment or is this restriction? What I would be submitting before your Lordship is that it is both. It has two parts, subject to and law. So subject to restricts and law confers. Now, let me first clear I think it is a confusion which has occurred whether the term law as used in Article 191 means or includes acts of Parliament or not. My Lord, in order to understand this, my Lord, let us first go to the Supreme Court rules and let us examine how the Supreme Court, full court in 1980 which sat, looked at this term law, and the answer lies in that. If I may take your Lordships to the Supreme Court rules, Order 11, which is the critical section dealing with the Chief Justice being the master of the roster. How did they understand this term law? If your Lordships have Order 11, my Lords. Ji. If I may read, and I'll only read the first line, critical line. Save as otherwise provided by law or by these rules. Now, your Lordship may notice the language in this. Save as otherwise, critical word, otherwise, provided by law. My Lord, a bare reading of this provision shows that one is envisaging some kind of statutory law. And I will come to the words otherwise later. Otherwise indicates that if law here refers to act, there may be some other arrangement in some other statute.
Subject to otherwise provided by law, what? Pura padhiye na isko.
By law.
No, kindly read the whole.
Save as otherwise provided by law and by these rules, or every cause.
Or by these rules. Or by these.
Or by these rules, every cause, appeal or matter shall be heard and disposed of by a bench consisting of not less than 3 judges to be nominated by the Supreme Court.
But this goes to the strength of the bench, not who is to sit on the bench.
So, I'm not coming to, I'm simply saying, how do we understand this term law, which occurs in Article 191? An indication of that is given in this order. This clearly implies some kind of statutory law, and I'll come to the words otherwise later when I examine what is the relationship between rules and act. Now, to further clarify that the word law must include an act of Parliament, there is a definition section in this Supreme Court rules. Now, your Lordship may kindly come to that. If your Lordships may kindly see Order 2.
Mr. Siddiqui,
yes,
the question was that if it is only to be an act of Parliament, then the Constitution might have used the word act of Parliament, not that the word law includes an act of Parliament. The whole issue was that subject to law, law is a very broad term, yes, includes many things, including an act of Parliament. Yes. And the Attorney General said that we should read into the word law the fact that it's just an act of Parliament. Hence the issue as to how to read the word law. आप जो बहस कर रहे हैं कि law में act of Parliament है वो तो understood है. सिर्फ ये है कि to the exclusion of everything else हम इसको law में पढ़ेंगे.
मैं to the exclusion argue नहीं कर रहा हूँ, and the reason I am trying to clarify so that there is no confusion is to come to my argument about conferment under Article 190. If I may just make one point on this.
You see, there are two issues here.
Yes.
I interject now. I'm here to hear you. Please conclude your submissions. If someone wants to ask a question, if you start responding to each query, I don't even know what your argument is. And I would request the honorable members of the bench to at least let counsel complete his submission. Yes, there will be questions, but I don't know what you're going to say next. And if you are faced with questions, I mean, I don't know what I'm to write, and I just lose the chain of thought, and I'm sure you do as well. So, Mr. Siddiqui, please, if you keep responding to each question, we'll be forever. No, excuse me, this is no laughing matter.
Well, Lord,
no, from morning to night on the first day we worked, every second of this court is time of the people who have invested heavily in this institution. 3 full days have worked. Now we are on the 4th day. We can endlessly hear one case in the year, and that's a performance. And all the other cases will get left behind, and all they will keep mounting up. So please, there are 15 of us, and all of us have questions, and undoubtedly valid questions. Please complete your chain of thought, and if you keep responding, I don't know what your contention is, I will never understand it.
If I may just complete this.
Please keep submitting your submissions.
I'm very grateful to your Lordship. If your Lordships may see Order 1, it contains various definitions, my Lord, and then your Lordship may see subsection 2. If I may read. Unless the context, now law is not defined in the Supreme Court rules, but this provision is there. Unless the context otherwise requires, the General Clauses Act 1897 shall apply to the interpretation of these rules, as it applies to the interpretation of a federal act. Your Lordships are aware that the term law is a defined term in the General Clauses Act. And this is the General Clauses Act 1897 I'm talking about. If your Lordship looks at Section 3, subsection, sorry sir.
Order 1, 2, 2 है ना जरा clear कर.
जी.
Order 1 का rule 2 का 2.
जी, rule 2.
जी.
Rule 2 का 2.
जी. जी, rule 2 का 2. I'm sorry sir. So the definition of what law means in Order 11 would come from the General Clauses Act. And Section 3, subsection 37B has a definition of law. It says Pakistani law, but the case law consistently says where the term law means Pakistani law, that is what Pakistani law is. And it says Pakistani law shall mean any act. Ordinance, regulation, rule, order, bylaw.
Please tell us where you're reading from.
Sir, Section 3, subsection.
Sections to nahi hai.
Sir, General Clauses Act 1897.
अच्छा, we are still at the rules, जी.
Sir, rule तो मैंने आपको बता दिया. Order 1, sub rule 2. अगर आप General Clauses Act देख लें आप, Section 3, subsection 37B.
37. Pakistani law.
So there is, as the Supreme Court which sat while making these rules, was clear in their minds.
It says Pakistan law.
Yes, and the case law says that where the word law comes in statutes, and I've given the citations, I won't repeat them, that Pakistani law's definition is to be used. I've cited that. So, my lord, there is no doubt about the fact that when the word...
This is the book that I have, subsection, there's a note here saying that this was substituted in 1981.
Ji. So, 37B.
Yes, it was substituted in 1981, what you are reading. So when the full court sat to frame the rules in Supreme Court Rules 1980, what was 37B then?
But it would still apply.
No, but what was it?
I'm not aware of that, but
Check.
yes.
I will check.
So my submission before your lordship is that even if one looks at the structure of the sentence, save as otherwise provided by law, the contemplation in the mind of even while framing the rules is that there can be an act of parliament. Now, what is the relationship between that act of parliament and the rules? That is a crucial question. But there can be no question about the fact that rules, act of parliament can be on practice and procedure of the Supreme Court.
No, it can't.
So that's my first point.
Just a moment.
Ji sir, ji sir.
First of all, you are asking us to read a definition which does not say law but says Pakistani law in the specific context of Article 191 and the Supreme Court rules. Okay, that's your argument. But you say that law...
I don't know what you say. I still have to note it. Can you please complete your thought? So let me understand what you're saying. So then the question, I will understand the question also. Maybe I'm not so quick at understanding. Can you please complete your submissions from your own mouth? Let us hear it.
My submission is that the word...
Let me first ask up to whatever you said.
Please,
now.
can you... I don't know the question has to follow a submission. Please, can you conclude your submission, Mr. Tehsil Siddiqui? Otherwise, we'll have to spend forever on this case.
Sir, may I...
आप जरा अपना conclude कर लें submissions.
May I just... Thank you, sir. Thank you. Sir, my submission...
I can't follow what you're saying.
Sir, my submission is that the word law, as it occurs in Article 191, includes acts of Parliament. And an indication of that, a clear indication of that is given in the rules as framed in 1980, because the language, for example, used in Order 11 talks about save as otherwise provided by law. That clearly indicates that one is talking about statutory law.
Okay, next point.
Yes, yes. And that of course is buttressed by the definition.
Just before you carry on to your next point, I think, if I may ask, in the 1956 Constitution, you will recall that there was a specific article which said that words and phrases not defined in the Constitution shall have the same meaning as in the General Clauses Act.
Yes.
That was in the 1956 Constitution. Yes. Is there any equivalent in the 1973 Constitution? As far as I can...
I don't...
Mr. Tehsil Siddiqui, you have been...
I'm not aware of it.
You have been rightly stumped. Please persist with your submissions.
Therefore, my question to you is that here we have to look at the word law as used in Article 191, because the rule-making power is conferred by Article 191. So any definition, anything that goes in the Supreme Court Rules 1980 has to be consistent with the language of Article 191.
I'll come to that. My short answer...
Kindly you focus on that.
Yes.
What does law mean over there?
My short answer...
I think council...
Sir, I'll just complete my
I think council is entitled to argue any which way they want to. Let us hear you.
Yes.
I have to hear you decide what you say, and if we have already formed opinions, we can reflect them in our judgments. Please continue, otherwise we will never conclude these hearings.
This is a question that as a judge of the court sitting on this bench, I am entitled to ask.
Of course, ask it. Let the council finish his submissions.
If I'm interrupted all the time, I'm sorry to say, sir, that is not proper.
I think the interruption is of learned council. Chale learned council, aap aage badhein.
I am asking council a question, which is my right to ask the council. If he wants to answer
after he concludes his submissions with the greatest of respect.
Doesn't want to, that's his issue. That's not my issue. You understood the question now?
My lord, I'll address that question. Let me just finish this submissions on competence and then I'll address this question. My lord, so I think there can be no doubt about what the word law means in Article 191 in the context type. But if your lordship requires a constitutional context, then subject to law also occurs in the Constitution, and it has been interpreted by your lordships of what that means, and that has been interpreted as meaning an act of Parliament. A recent judgment on this is a judgment authored by Justice Mansoor Ali Shah Sahab in the extension case, which is PLD 2020 Supreme Court, page 1. And your lordships are aware, if your lordships look at 243, sub-article 3, which contained the same language, although subject to law was not in the beginning but in the middle. The President, subject to law. And His Lordship Justice Mansoor Ali Shah in para 27 of that judgment said this means an act of Parliament. So then another judgment, my lord, on this would be the Baskakar case. Now, if your lordship, as your lordships are aware,
Baskakar.
Yes.
Baskakar.
Baskakar.
Okay.
But the law has been defined in the Constitution.
No, no. Existing law has been defined.
Kindly see 260.
Federal law is also.
Federal law has been defined.
Law has not been defined. Existing
Federal law has been defined.
Federal law has been defined.
Please continue your arguments.
When 191 says of a law, does it talk of existing law or does it include a law that subsequently may be legislated?
It cannot talk about existing law because existing law is a defined term in the Constitution under Article 260. And that is a reference to Article 268, sub-Article 7. So when existing law is used, it's a defined term in the Constitution.
So where it is defined, then the Constitution must have used the term existing law somewhere.
Yes, in
where is that?
268.
No, वो तो defined हुई है ना?
It is in 260.
Other than the definition, where in what articles, what other articles has this term been used?
It is being used in 268. It has been defined and used in that, as far as I am aware. But it is a defined term. So if they wanted to use existing law, existing your law would have been used.
Mr. Siddiqui, it seems that, albeit the fight is about me as being as a master of whatever, you're not hearing what I'm saying at all, and you're completely ignoring.
Sir, I'm not,
I mean, you don't want to make your submissions. You should just sit down and answer questions.
I'll complete my submission.
So why aren't you making your submissions?
No, my lord, leaving aside the issue.
Mr. Faisal Siddiqui, just 1 minute. You've given the example of Article 243. The President shall, subject to law, have the power to do what? Raise and maintain military, naval and air forces of Pakistan and so on. But the difference between law over here is, and this is the point that yesterday was made with other learned counsel, that this relates to a specific entry of the Federal Legislative List, i.e. entry number 1. Law over here is relatable to entry number 1, a specific entry
I'll come to that.
Federal Legislative List. And this was in relation to Article 202.
No, I'm simply saying that the word term subject to law as used elsewhere has been judicially defined in a certain, whether Article 191...
There's a context, what I'm asking you is, there's a context to Article 243, and a context that appears to be missing in relation to Article 191, where there is no specific entry, for example, in relation to the Supreme Court. So which particular legislative list would you link the use of the word?
That is where I am coming to, my lord. When it comes to practice and procedure, I will be relying on entry 58. When it comes to the appellate jurisdiction under section 5, I'll be relying on entry 55. So I'll come to now this submission. I just wanted to clear as far as this word law is concerned. Now, let me come to my first part. As your lordships are aware, there are two parts to this law. One relates to practice and procedure, and then there is section 5 which relates to appeal. Although there is a judgment by His Lordship Justice Munib where he has said as far as legislative competence is concerned, even appeals are a part of procedural law. I'll be referring to that judgment. So, if appeals are also a part of procedural law as far as legislative competence is concerned, then they would even be covered in practice and procedure law. So let me first come to how practice and procedure is covered. My Lord, if your Lordship may kindly see my note, I rely on entry 58, read with Article 191, my Lord. Now, my Lord, it is, if your Lordships accept my argument, which is that subject to law also includes acts of Parliament, if I can safely make that presumption, then in order not to make this word redundant, there must be some power with someone to make this law in the Constitution. Otherwise, the word will become redundant, my Lord. Now, that power, my Lord, cannot be based on entry 55. It has to be based on entry 58. The reason I say that is entry 55 deals with, as apart from practice and procedure, it deals with jurisdiction and powers. When one is talking about practice and procedure, one is not talking about jurisdiction and power. I make that distinction. Now, a question was raised as to entry 58. If I may draw your Lordship's attention to entry 58. It's quite a complicated entries, both of them, my Lord. If your fourth schedule, sir, entry 58. Now, a question arose as to a very important term which is used in both the entries. It is by or under the Constitution. Entry 55 uses the word by or under the Constitution. Entry 58 only uses the word under the Constitution. If I may read, matters which under the Constitution are within the legislative competence of Majlis-e-Shura or relate to the Federation. What does this term under the Constitution mean as opposed to the word used in entry 55 by or under? My Lord, this is a term which is used in the Constitution also, by and under the Constitution. It's used once in Article 69. It's used under the Constitution, is also used in other parts of the Constitution. Now, I think the answer is something which Justice Ijaz had given, is that under the Constitution means the necessary implications. So that is how at least the Indian Supreme Court has understood this. What necessarily follows from a certain article. It's like something which can be prima facie implied from an article. Now, my submission as far as Article 191 is concerned, my Lord, is that it is not something which is very different from the rest of the entries, as Justice Munib had observed yesterday. I think it's a substantive entry. And that is how it's been understood by the Supreme Court in the Sui Gas case. There's a whole para on entry 58 and 59, that these are independent and substantive entries in the Constitution, which independently and substantively confer competence. Now, my submission before your Lordship is very simple, which is that if law in Article 199 means Act of Parliament, and if we are not to read law as in 191 as redundant, then there has to be legislative competence which has to be found somewhere for practice and procedure. Now, that place where it is found can either be entry 55 or entry 58. It cannot be entry 55 because we are not talking about jurisdiction and powers. It has to be entry 58. And entry 58 contains the key words, which is not by the Constitution but under the Constitution, as necessarily being implied. The necessary implication of an article is that it confers judicial power. So that is why one part of subject to law.
Entry 58 with what? With which article of the
191, and I also
191, you see, as the language is, the simple reading of 191 says, it is a power conferring article, and that power is conferred on the Supreme Court. So ultimately, the rules which have to be framed under Article 191 is a power of the Supreme Court, not of the Parliament.
My lord, there are two conferring powers.
In framing the rules, the Supreme Court is supposed to follow the Constitution, and I would tell you, speaking for myself, any existing law or any law that was prevalent or was in force at that time. Entry 191 does not, Article 191 does not confer legislative power on the Parliament to frame rules for the Supreme Court.
My lord, then the words under the Constitution would have to be given another meaning, because there is express conferment, as your lordships have seen in Article 188, through an Act of Parliament. And there are necessary implications, conferments which follow from the article.
आपका तो entire thesis ये है ना कि जी law का मतलब ये है an act of the Parliament, whether it is existing or it is subsequently made.
Yes, yes.
ठीक है? वो उस सूरत में होता जब 191 में लिखा होता the rules of the Supreme Court shall be framed by the Parliament. या what was the fun or what was the rationale of giving the power to the Supreme Court in the chapter of judicature and at the same time turn around and say, well, you can frame the rules, you may frame the rules, but once you have framed the rules, the Parliament can override those rules.
Because it is a limited power. The reason is the structure of 191 is that the primary power, the primary duty under 191 is given to the Supreme Court too, so that its internal autonomy is but.
So where the primary power or the primary duty has been discharged, then the matter ends there.
No, it doesn't end there. That is why your lordship will see I broke subject to law into two parts.
Because
there is law and there is subject.
Why do I say that?
Yes.
Because the entire structure of the Constitution ensures that the judicial branch shall be insulated from not only the executive but also by the legislative intrusion. Okay? So, conferring the power to the Supreme Court means that insulation has to be maintained. Now, once you confer the power on the Parliament to override those rules, that insulation goes. Because, as it was argued yesterday, or at least it was observed yesterday, that this is an intrusion into the autonomy of the Supreme Court, which is the main theme of the Constitution.
May I address this question when I deal with the relationship between the Act and the rules? Which will prevail in what circumstances? Because that is what
ये जो amendments हैं, do they or do they not interfere in the internal working of the Supreme Court?
Sir, the criterion is not whether they interfere in the internal working of the Supreme Court.
That is the criteria
I'll
of
show,
independence.
No, my lord, I will say there are 4 restrictions on Parliament as far as its legislative authority is concerned under Article 191, read with entry 4. Let me first state that, then I'll explain. The first restriction is that under 191,